Thank you very much, Anne-Marie. On behalf of the trustees of the Ecclesiastical Law Society, can I welcome you warmly to this evening's London lecture. Ordinarily, of course, we would have been enjoying the hospitality of Winkworth Sherwood in London for this evening's lecture, but continuing restrictions mean that we meet on Zoom. Now, this, of course, does afford us the benefit that so many of us can join from around the country and indeed around the world. And so can I especially welcome those of you who are not members of the ELS. Please do consider joining the Society. Details of how to do so are on the website. We are very fortunate indeed to welcome Paul Morris, who will deliver our lecture this evening. Had we been meeting in person at Winkworth Sherwood, then there would have been a sense that Paul was returning home. For on his qualification as a solicitor in 1978, he joined the firm now called Winkworth Sherwood and was senior partner there from 2003 to 2010. Throughout his career spanning 4 decades, Paul was active in legal work for the Church of England, and until his retirement in August of last year, Paul served for many years and with great distinction as Registrar of the Diocese of London and Southwark, as well as Chapter Clerk of Southwark Cathedral. So Paul, it's great to have you with us, and without further ado, I'm going to hand over to you. Paul is going to deliver this evening's lecture entitled Landmark Events in Ecclesiastical Law During 4 Decades. Thank you, Paul.
Well, thank you. Thank you, Stephen, for that very kind introduction. And it's really great to be with you all this evening. And really nice to see so many familiar faces and names. It's quite nostalgic. This evening's lecture is not going to be an academic one, although I will talk about quite a lot of law. Inevitably, it's a selective retrospection, but one which I hope will help illuminate how we got to where we are today. My working life in ecclesiastical law resulted from a chance conversation in a small boat off the north coast of Cornwall. I was on a mackerel fishing expedition with a friend. My companion was a young solicitor. He and I had been trainee solicitors, or articled clerks as we were called then, in the same firm in the Strand, London. My friend was a couple of years ahead of me and had just become a junior partner in the newly expanded firm of Winkworth and Pemberton, later to become Winkworth Sherwood. He was not himself an ecclesiastical lawyer, but he told me his new firm acted for several bishops and diocesan boards of finance, and that recent legislation was going to increase the amount of transactional property work needed by the boards. He said his ecclesiastical partners were looking for a newly qualified solicitor to help them with this. Knowing of my Anglican background, he wondered if I might be interested in applying. The rest, as they say, is history. We also landed an impressive catch of mackerel. The new legislation referred to was the Endowments and Glebe measure of 1976. This had just come into full effect at the time that I joined Winkworth and Pemberton in 1978, and it figured prominently in my working life at the outset. The passage of the Endowments and Glebe measure had not been without controversy. The General Synod, into which the old Church Assembly had metamorphosed in 1970, was still relatively new. It took 2 goes and much persuasion to get the support of the Ecclesiastical Committee, composed of members of both Houses of Parliament. The Glebe measure was then the subject of a full debate in the House of Commons. Among those who spoke out strongly against it was Enoch Powell. Why should this be? Well, that debate was really as much about the rightness of the Church of England regulating itself in these matters. For example, by extinguishing or modifying existing trusts, as it was about the measure itself. Nevertheless, it was the radical provisions of the legislation which provoked the debate. Despite strong opposition, the House finally approved the measure, albeit with a significant minority of dissenters. Briefly, the measure at a stroke transferred all the glebe land previously owned by the incumbents of individual benefices to the relevant diocesan boards of finance. It also dealt with endowment income, effectively confiscating this and replacing it with what was called a guaranteed annuity of up to £1,000 to be paid by the church commissioners. Where the endowment income of a benefice exceeded £1,000, an additional personal grant was payable by the commissioners. The personal grant ensured that an incumbent who had received a significant income from endowments continued to receive an equivalent amount, although only while he, and it was always he in those days, held that particular incumbency. If he moved to another parish, he would receive only the new standard stipend, as would any successor incumbent. The longer-term effect was, of course, to even out the stipends of incumbents across each diocese. That was the objective. Now, some parishes had very considerable glebe estates, all of which became the property and the management responsibility of the relevant DBF. For example, there were extensive residential glebe estates in Enfield and in Twickenham within the Diocese of London. In many such cases, the diocese decided to sell the freehold reversions wherever possible. Initially, the consent of the church commissioners was required to each sale under Section 20 of the measure, although this was subsequently relaxed by amending legislation. These glebe freeholds were almost invariably unregistered land. Pretty well without exception, no title deeds were known to exist. Title had to be deduced by statutory declaration, often by whoever had been employed to collect the rents on the relevant glebe estate. Purchasers' solicitors would be provided with a list of names of incumbents of the benefice since 1925, with dates of tenure. This was for the purpose of their land charges searches, for of course, they were acting in the purchase of unregistered land which had vested in the individual incumbents from time to time. It was considered necessary to search against each incumbent by name as estate owner in respect of the period of their incumbency. It was traditional steam conveyancing of the kind which was familiar before land registration became almost universal. I remember that the consent of the church commissioners was in each case evidenced by letter, and that we made use of an annotated form of conveyance, a copy of which we provided to purchasers' solicitors, and for which they were usually grateful. By means of numbered footnotes, this model document drew attention to the relevant sections of the 1976 measure and clarified the devolution of title. Well, the Endowments and Glebe measure seems like ancient history now, but it was a landmark event at the time, and I think its legacy lingers in a degree of suspicion of the diocese on the part of some parishes. The measure has now been partly consolidated with some amendment in the church property measure of 2018, but its principles and purpose remain unchanged. Of course, there was much other legislation which an ecclesiastical property lawyer would have encountered at the end of the 1970s, notably the 1938 Parsonages Measure, the New Parishes Measure of 1943, and the Pastoral Measure of 1968, all of which were consolidated, reenacted, and amended by later measures. However, there was another aspect of ecclesiastical law which a church property lawyer could not avoid for long. And so it was for me. I refer, of course, to the faculty jurisdiction. Now, my first encounter with a diocesan chancellor was certainly a landmark for me. It was rather an alarming experience. As a fresh-faced and inexperienced assistant solicitor, I was instructed by a parish in the Diocese of London in a faculty case. The petition was actually unopposed, but the Chancellor of the day, the great George Newsom, liked to have hearings, so I had to appear before him. In outlining the background to the petition, I said that the proposals had been approved by the Diocesan Advisory Committee. I had said the wrong thing. Approved? Roared George Newsom. The DAC can't approve anything. Only I could approve. I never made that mistake again. But later, as de facto Deputy Registrar, I had many enjoyable and instructive conversations with George Newsom as we travelled to hearings in different parts of the diocese. Some of you will remember Chancellor Newsom's elegantly written textbook, Faculty Jurisdiction of the Church of England, now superseded by more recent publications, including those by Dr. Miners and by Professor Hill. The Newsom book is nevertheless still worth a read. Now, at the time of my first foray into the faculty jurisdiction, Gerald Ellison was still Bishop of London. On the other side of the River Thames, in the Diocese of Southwark, Bishop Mervyn Stockwood was approaching the end of his memorable reign. These were still the days of what was called South Bank religion. Some of you will know that there had been a tremendous feud between Bishop Mervyn and his Chancellor, Garth Moore. Relying on a reservation in the letters patent appointing the Chancellor, Bishop Mervyn decided that he, as bishop, would sit as judge in his own consistory court, thereby ousting the Chancellor. The bishop even arranged for the Chancellor's imposing stall to be removed from the choir of the cathedral to the retro choir, where it remains to this day. Shortly after Bishop Mervyn's retirement, the case of St. Mary Barnes came before the Southwark Consistory Court. This was a case which had been dealt with at an earlier stage by the bishop himself. For diplomatic reasons, the then Registrar of Southwark decided he couldn't sit with the Chancellor, so he deputed me to do so. When the Chancellor delivered his judgment, I listened with astonishment to a ferocious attack on the former bishop. The Chancellor said, amongst much else, that the bishop's behaviour represented, and I quote, a return to the absolutism of the Middle Ages, condemned in this country since at least the middle of the 17th century. I realised then that consistory court proceedings could be far from dull, and that Trollope's literary portrayal of goings-on in the Church of England was not, after all, an exaggeration. Much water has flowed under the bridges of the River Thames since those distant days. The faculty jurisdiction has evolved, there's been new legislation, rules have been revised, the simplification process has reduced the number of cases which need to come before the consistory court. Importantly, though, the so-called ecclesiastical exemption from listed building and conservation area control has survived. This, of course, applies only to places of worship in use as such. In 1994, the exemption was narrowed by way of an order made by the Secretary of State so as to apply only to the Church of England and Church in Wales, as well as to our Roman Catholic, Methodist, Baptist, and URC brethren. Importantly, too, the role of the Diocesan Advisory Committee was also strengthened. A major change was effected by the Care of Churches and Ecclesiastical Jurisdiction Measure 1991. This, for the first time, required DACs to adopt a written constitution and laid down prescribed requirements as to membership. These involved consultation with the principal heritage and amenity bodies. Previously, DAC members were appointed by or on behalf of the bishop, and there had been wide variations from diocese to diocese as to composition and membership. The 1991 measure, which came into effect on the 1st of March 1993, also made it mandatory for the DAC to be consulted in most faculty applications, and for this consultation to be in advance of the lodging of a faculty petition. Previously, the Chancellor would decide whether or not to seek the advice of the DAC after a petition for faculty had been submitted. Furthermore, a formal DAC certificate was now required. Later, of course, it became the notification of advice, although then, as now, the Chancellor as judge was not bound to follow the DAC's advice. Over the years, there have been many other changes of detail. De minimis lists of things which could be done without a faculty became an official minor matters list, and eventually developed into lists A and B, with certain things being permitted with the consent of the Archdeacon and other things not requiring consent at all. One of my favourite items on an old de minimis list was the repair of harmoniums with matching materials. It reminded me of an instrument I knew in my youth, which was blown by what were proudly labelled as patent mouse-proof pedals. I wonder if those mouse-proof pedals ever required matching replacement. Perhaps they needed a faculty. I wonder too what Chancellor Newsom would have thought of the present position in respect of consistory court hearings. Until the recent amendment to the rules, a formal party opponent in faculty proceedings was entitled ultimately to require a hearing in open court, albeit with the potential risk of an order for costs being made against them. That has now changed so that a Chancellor may decide that a hearing should not take place, even if a party opponent wants one. Moving on from the faculty jurisdiction, a recurrent theme during my working years was the question of the employment or quasi-employment status of the clergy. On the face of it, prior to the introduction of common tenure in 2011, the situation was relatively simple. The beneficed clergy, incumbents with the freehold, in practice enjoyed almost unlimited security of tenure. In extreme cases, removal was possible under the clergy discipline measure once that came in, or under the ecclesiastical jurisdiction measure of 1963. Removal in cases of pastoral breakdown or mental or physical infirmity was also possible, at least in theory, under the incumbent's vacation of benefices measure 1977. Retirement at age 70 was mandatory in most cases under the Ecclesiastical Office's age limit measure 1975. Removal on grounds of pastoral reorganisation was also theoretically possible, although the substantial cost in statutory compensation to an ousted incumbent discouraged this. The situation as regards compensation has recently changed, of course, and the statutory compensation is very substantially reduced. By contrast, the licensed clergy, for example, curates or priests in charge holding the bishop's license, but not instituted into a benefice, had very much less security. A bishop could terminate a license at any time on reasonable notice, generally thought to be not less than 6 months. It was not necessary for the bishop to give any reason. That situation continued to exist until the introduction of the Clergy Discipline Measure 2003, which made it illegal for a bishop to terminate a clergy person's license except by way of formal process under the measure, if the real reason for doing so was a disciplinary one, which it often was or could be argued to be. Now, we don't have time this evening to go into this topic in detail, but there is one case which arose in the Diocese of Southwark, which provides a vivid illustration. Put broadly, the received wisdom for many years was that the parish clergy and their equivalent in other denominations are office holders who are not employed under contracts of service, and that whatever control is exercised over them is not exercised by any employer in the legal sense. This was supported by a long line of cases going back to before the First World War. The case of Coker against Diocese of Southwark, 1997, put all this under the spotlight. Dr. Alex Coker was born and brought up in Sierra Leone. He was ordained as a non-stipendiary minister in the Diocese of London in 1986. In 1989, he was appointed as stipendiary curate of St. Luke Woodside in the Croydon Episcopal area of the Diocese of Southwark. In 1993, Dr. Coker's curacy at Woodside was brought to an end by the requisite written notice given by the vicar with the consent of the Bishop of Croydon. Dr. Coker was not immediately able to find another post, so the Bishop of Croydon arranged a further 6 months curacy at St. Philip, Cheam Common. This curacy was also brought to an end. Dr. Coker applied to what was then the Industrial Tribunal, claiming unfair dismissal. He also, by the way, claimed racial discrimination. This latter claim was particularly tantalizing because the then Bishop of Croydon, Wilfrid Wood, was at the time the only black bishop in the Church of England. However, the discrimination claim was out of time and therefore couldn't be pursued. Nevertheless, to the shock of many, the Industrial Tribunal, in the person of Professor Roger Rideout, deciding a preliminary point of law as tribunal chairman, held that Dr. Coker was indeed an employee and entitled to proceed with his claim for unfair dismissal. I should just mention that Professor Rideout was at the time a respected professor of employment law at University College London. His view did carry some weight. Very briefly, Professor Rideout's reasoning was this. 1. Dr. Coker was not an office holder in either of his curacies because the post of curate in the Anglican Church is personal to the holder of it. 2. A contract was created by the acceptance by Dr. Coker of the offer contained in the letter from the Vicar of St. Luke's offering him the job. 3. The contract was a contract of employment. There was personal service by Dr. Coker which he could not delegate. There was a high degree of control by the vicar on behalf of the diocese. Dr. Coker was not economically independent, and the spiritual element in the curacy was not sufficient to outweigh the element of personal service. The diocese appealed to the Employment Appeal Tribunal and won. Dr. Coker appealed to the Court of Appeal. The Court of Appeal unanimously dismissed Dr. Coker's appeal. Here is part of what Lord Justice Mummery said in the judgment. I agree with the Employment Appeal Tribunal that the chairman of the Industrial Tribunal misinterpreted the law, which has been settled by a long line of authority. In my judgment, the legal position is as follows. 1. Not every agreement constitutes a binding contract. Offer, acceptance, and consideration must be accompanied by an intention to create a contractual relationship giving rise to legally enforceable obligations. 2. That intention is to be objectively ascertained. In the case of an ordinary commercial transaction, it will be for the person who contends that there was no contract to establish that the intention to create a binding contract has been negative. 3. In some cases, however, there is no contract unless it is positively established by the person contending for a contract that there was an intention to create a binding contractual relationship. This is such a case. Special features of the appointment and removal of a Church of England priest as an assistant curate and the source and scope of his duties preclude the creation of a contract unless clear intention to the contrary is expressed. Lord Justice Staunton added the following: I agree with the analysis of Lord Justice Mummery and his conclusion that in general the duties of a minister of religion are inconsistent with an intention to create legal relations. There may be some subsidiary contract as to a pension or the occupation of a house, but there is not a contract that he will serve a terrestrial employer in the performance of his duties. The next case I want to mention concerned not a licensed curate, but a freehold incumbent. It dates from my time as joint registrar of the Diocese of Leicester in the 1990s. The incumbent concerned was the Reverend Ashley Cheeseman. The parish was the parish of the Glebe group, a grouping of 7 villages and hamlets in rural Leicestershire. Mr. Cheeseman was a conservative evangelical priest whose style of ministry did not appeal to a significant group of his parishioners. A previous parish priest had been a popular figure at local parties and social events, but this was not Mr. Cheeseman's métier. He caused dismay by condemning fundraising events such as local barn dances as heathen, and by the perceived severity of his sermons, and by his alleged lack of pastoral care. His opponents in the parish were determined to get rid of him. For a time, it looked as if they might get their way. On January the 30th, 1989, Mr. Cheeseman went into a public lavatory in Leicester, which was notorious for cottaging. There, he allegedly exposed himself willfully and indecently to 2 men who turned out to be police officers. He was charged and subsequently convicted, having also been suspended from his duties as rector. It looked as if the game was up, but it wasn't. On the advice of his solicitor, Mr. Cheeseman appealed against his conviction. This was on the ground that under the relevant statute, I think it was one of the Vagrancy Acts, he had been charged with exposing himself to the annoyance of passers-by, and the 2 policemen didn't fall into that category. The Court of Appeal agreed. The conviction was quashed, albeit on a legal technicality. Mr. Cheeseman resumed his duties and decided he wanted to remain as rector of the Glebe group. Others had a different view. Initiated by the PCC, proceedings were begun under the incumbent's vacation of benefices measure 1977 on the ground of alleged pastoral breakdown. Those proceedings got as far as an initial hearing, but the costs spiraled alarmingly, and in the end, the proceedings were abandoned. However, the then Bishop of Leicester, Bishop Tom Butler, who subsequently moved to Southwark, was determined to try to resolve the unhappy pastoral situation. He discerned that the principal opposition to Mr. Cheeseman was concentrated in, I think, 4 of the 7 villages. In consultation with his pastoral committee, he came up with proposals for pastoral reorganisation, which would remove those villages from Mr. Cheeseman's parish, leaving him with a reduced flock in the remaining communities who were thought to be more amenable to his style of ministry. Mr. Cheeseman would, however, remain in his parsonage house and continue to receive his stipend. The church commissioners produced a draft scheme on that basis. From a legal perspective, the question was whether or not this was a proper use of the pastoral measure 1983, as it then was. After all, this very shortly followed the previous abortive attempt to remove Mr. Cheeseman from office. Was this vacation of benefices by the back door? Or was this a legitimate response to a pastoral need? Mr. Cheeseman made representations in objection to the proposed Church Commissioners scheme, leading ultimately to an appeal to the Judicial Committee of the Privy Council. The committee supported the proposed reorganisation by a majority decision of 2-1. The bishop, via the commissioners, had won. For Mr. Cheeseman, though, the episode literally ended in tears. He wept as judgment was delivered in the Privy Council chamber. The rumour at the time, and I really don't know whether or not this is true, was that prior to that moment, he genuinely believed he had won. The unconfirmed story is that someone leaked the judgment to him in advance, but that the leaked judgment was actually the dissenting one of the chairman, Lord Lloyd, who came out in Mr. Cheeseman's favour. The majority decision was, of course, the opposite. This theme of challenges to the use of pastoral legislation by bishops and dioceses was also a recurrent one during my working life. Another case which attracted attention at the time involved Bishop Tom Butler's immediate predecessor as Bishop of Southwark, Roy Williamson. It concerned the parish of St. Luke, Kingston, and the use by the bishop of the power to suspend presentation to a benefice. St. Luke, Kingston was and is a parish of traditional Catholic churchmanship. When the benefice became vacant in the early 90s, the bishop, who was also the patron, felt that the parish could no longer justify a full-time incumbent. With the consent of his pastoral committee, he therefore suspended presentation with a view to appointing a half-time priest in charge who would receive a half stipend. The church wardens and PCC were not happy. One of the church wardens happened to be a solicitor, and he quickly familiarised himself with the relevant provisions of the 1983 pastoral measure, as it then was, and in particular with the Church Commissioners' Code of Practice issued for use with the measure. He also instructed counsel. The Code of Practice said that, in the main, the power of suspension should only be used when there were plans for pastoral reorganisation, or if for some reason the parsonage house was unsuitable and needed to be replaced. This gave rise to the question of whether or not in law, the bishop's power to suspend for a renewable period of up to 5 years was a freestanding one, subject only to the consent of the Diocesan Pastoral Committee, or whether the Code of Practice imposed restraints on the exercise of the power. The solicitor church warden, not surprisingly, took the latter view. The church wardens and PCC applied to the High Court for leave to bring judicial review proceedings against the bishop. After hearing argument on both sides, leave was granted by Mr. Justice Brooke. However, the substantive issue was never determined judicially because the parish and diocese reached an amicable settlement. Inquiries carried out at the time, however, revealed that the power of suspension was being extensively used by some diocesan bishops, more so than was actually the case in Southwark, as a means of restricting the number of parish clergy with a freehold. Mr. Justice Brooke drew attention to evidence before him that in the Diocese of Southwark, of 394 parishes, 42 were suspended. In the Diocese of Ely, out of 258 parishes, there were 94 suspensions. And in the Diocese of London, out of 407 parishes, 90 were suspended. The issue of suspension of presentation brings me to a parish in the Diocese of London, which has been suspended continuously for more than 30 years. The parish is St. George, Hanworth, and the parish priest, throughout almost all my time as Registrar of the diocese, was Father Paul Williamson. Father Williamson was ordained and served his initial curacy in the Diocese of Southwark. He moved to the Diocese of London in 1978 and was priest in charge at Hanworth from 1992. He was a figure familiar to us in the registry for very many years. As is well known, Father Williamson was a vigorous and outspoken opponent of the ordination of women. He pursued his cause by way of prolific litigation, not only contesting the legality of the General Synod's legislation, but attempting to show that the Archbishops of Canterbury and York were guilty of treason on account of their alleged procurement of a breach of the coronation oath. By a civil proceedings order made against Father Williamson in July 1997, he was declared a vexatious litigant. A few years prior to that, in 1994, he had attended the first ordination of women priests in Southwark Cathedral. During the service, he shouted out his objection and was allowed to address the bishop and congregation. I was then asked to reply, which I did. The ordination continued. We had known in advance of Father Williamson's intention to object, but it was still a relief that the episode did not descend into unseemliness. Father Williamson's later legal exploits were not as constrained as one might expect by the civil proceedings order. Why was this? Well, there's much I can't say for reasons of both time and confidentiality. One quite recent reported case, nevertheless, provides an illustration. In 2016, an application for an injunction came before the former Chancellor of the Diocese of London, Judge Nigel Seed QC. The applicants were Father Williamson and one of his church wardens, although the application was signed by Father Williamson alone. The respondent was the London Borough of Hounslow. Briefly, the facts were these. Adjacent to the site and curtilage of the church and church hall was a residential estate of purpose-built sheltered housing, ownership of which had been registered at the Land Registry for some 69 years in the name of the London Borough of Hounslow or its statutory predecessor. There had been no previous challenge to that ownership. The borough proposed to redevelop the site to provide a modern, updated residential estate. It had planning permission to do so. Furthermore, a demolition contract had been let and a construction contract was pending. Father Williamson contended that the site was historically part of the churchyard of St. George's and that it was still subject to the legal effects of consecration. He also said that human remains had in the past been discovered on the site. At an initial case management hearing in Chambers, Father Williamson appeared in person. The borough was represented by Mr. David Lamming of Council. At the case management hearing, both the Chancellor and Counsel for the borough took the point that Father Williamson had been declared a vexatious litigant. The proceedings were stayed to enable him to apply to the High Court for leave to bring the application. That application was refused by Mrs. Justice Patterson, who concluded that there were no reasonable grounds for proceeding. Nevertheless, strong representations were made by telephone and letter to the registry, by Father Williamson and by others assisting or supporting him, to the effect that the PCC itself believed Father Williamson had a legitimate case and wished to see the application proceed. With some reluctance, the Chancellor gave leave for the application to proceed as an application by the PCC and not by Father Williamson. The Chancellor directed that Father Williamson was not to participate in the proceedings, although he would be permitted to give evidence if necessary. A hearing was duly held. The PCC was represented by one of the church wardens, who was subject to frequent prompting and intervention from Father Williamson. Father Williamson also gave evidence on oath. Briefly, the Chancellor concluded that the application was not supported by any compelling evidence and it was refused. In his judgment, the Chancellor commented that the application appeared to be, and I quote, an opportunistic and unjustified attempt to extract money from the borough. The matter of costs was reserved so as to give the PCC time to make representations in response to the borough's application for costs. The issue was subsequently determined by the Deputy Chancellor of the Diocese, Judge David Turner QC. Having considered representations from both parties, the Deputy Chancellor said this: "By any reasonable standard of interpretation, this application by the PCC was ill-judged, ill-conceived, ill-advised, and ill-prepared. In short, it was properly characterized as unreasonable. Arguments by analogy with more conventional faculty petitions where, following examination of the issues, a petition fails and objectors succeed, with the court expecting both parties thereafter to meet their own legal expenses, do not assist in the particularities of this case. It would, in my judgment, quite simply be unjust for the borough not to order the PCC to pay its costs in this case." Well, that case made important points about the conduct of proceedings before the consistory court and the possible costs consequences. In January 2020, this short item of news appeared in the Church Times in the section called News in Brief. The heading: "Priest lodges new age discrimination claim." And here's the report. "The Reverend Paul Williamson, who is fighting the requirement that he must resign as priest in charge of St George's, Hanworth, having reached the age of 70, has lodged a new claim against the Diocese of London on the grounds of age and religious discrimination. A tribunal hearing earlier this month declared his claim a nullity, but Mr Williamson has obtained the leave of the High Court to proceed with a new claim, and this has now been lodged. He is not allowed at present to preside at any further services at St George's. He spoke last week of the strain of taking this action." Well, I gather that matter remains pending, so it sounds as if Father Paul Williamson's contribution to ecclesiastical legal history has not yet reached its conclusion. We shall see what happens. Whatever the outcome, I think it's fair to say that Father Williamson has undoubtedly left his mark on the landscape of ecclesiastical legal history. Having spent some time talking about the litigious exploits of the clergy, I want to return now to another landmark piece of legislation. At the time of the 1976 Endowments and Glebe measure, there had been much discussion about the future of private patronage in the Church of England, by which I mean, of course, the legal right of a person or body to present a candidate for institution into a Church of England benefice. In the mid-1970s, there was a move to abolish private patronage. In fact, the General Synod got within a hair's breadth of resolving to do just that. The result, several years later, was a compromise. The Patronage Benefices Measure 1986 didn't abolish private patronage. Far from it. But it did modernize the law and aimed to introduce a greater spirit of partnership between patrons, bishops, and parochial church councils. The essential elements of the regime introduced by the measure have survived to this day with only minor procedural alterations, most recently by a legislative reform order made by the Archbishop's Council pursuant to the Legislative Reform Measure 2018. When I first joined Winkworth and Pemberton, I was already aware that a right of presentation, an advowson, was in law a form of property. I knew that it was an incorporeal hereditament and accordingly didn't have a physical existence. I knew it was held in gross, i.e. not attached, for example, to a specific piece of land. Prior to the 1986 measure, we dealt with transfers of advowsons by way of conveyance. And those deeds of conveyance looked virtually identical to a conveyance of number 2 Acacia Avenue, an unregistered residential property. Time doesn't permit a detailed analysis of the patronage benefices measure, but I should, I think, recap on its key points. First, it introduced a system of registration broadly comparable to that of land registration. Briefly, the registrar of each diocese is required to maintain a register of the patron or patrons of each benefice. The register is open to public inspection. I remember that the initial compiling of the registers was a considerable task. No patron may exercise the right of patronage unless registered. Any transferee of a right of patronage must apply for registration within 12 months of the date of the transfer. Any right of patronage which is not registered becomes vested in the Diocesan Board of Patronage. There are provisions for the determination of disputes and, in certain cases, a right of appeal to the Chancellor of the diocese. There are also provisions for the rectification of the register. Secondly, the ban on Roman Catholics and those of the Jewish faith being patrons, which previously existed, was abolished. A new system was introduced whereby anyone exercising a right of patronage was now required to make a written declaration of membership. That is, a declaration that the person concerned is an actual communicant member of the Church of England or of a church in communion with it. A patron not able to make the declaration or otherwise unable to discharge their functions as patron is able to appoint another person who is able and willing to make the declaration to act as the patron's representative. Thirdly, it was enacted that the right of patronage was not to be capable of sale, and any transfer for valuable consideration would be void. Fourthly, requirements were introduced for particular meetings of the parochial church council to be held. These are the meetings which have become generally known as Section 11 and Section 12 meetings, respectively. Under Section 11, the PCC is required to hold one or more meetings to do the following. A, to prepare a statement describing the conditions, needs, and traditions of the parish. B, to appoint 2 lay members of the PCC to act as representatives of the PCC in connection with the selection of an incumbent. These have become generally known as the parish reps. They don't necessarily have to be the church wardens. Ultimately, the parish reps have a right of veto, as does the bishop. C, to decide whether to request the patron to consider advertising the vacancy. The patron cannot be compelled to advertise. D, to decide whether to request a joint meeting with the patron and, if the bishop is not the patron, the bishop or their respective representatives for the purpose of discussing the parish statement and also the needs of the diocese and the wider interests of the church in relation to the benefice. If requested by either the PCC or the patron, the bishop is required to prepare a written statement on this latter point. Now, I wanted to set that out because these were important changes made by this particular legislation, but I won't bore you by going through the prescribed procedure for filling a vacant benefice. Many of you will be familiar with that anyway. It's worth saying, though, that the 1986 measure went some way towards meeting the concerns of those who objected to private patronage. The role of the church parties, in particular the PCC via the parish reps and the wider diocese via the bishop, was certainly strengthened. Yet private patronage was preserved and has survived for more than 3 further decades. Some of those who support private patronage argue that the transfer of advowsons to bishops, I'm using the words here of the private patrons consultative group, and I quote, tends to make the exercise of patronage more narrowly ecclesiastical, and silences a lay voice which centuries ago an original donor may have thought to have been secured in perpetuity. They point also to the variety of church traditions which the system helps to preserve. I like the story of Bishop Samuel Wilberforce, who, when Bishop of Oxford, travelled to an auction by horse. One of the items being auctioned was the advowson of St Aldate's, Oxford, now, of course, a famous evangelical church. On the journey, Bishop Wilberforce's horse lost a shoe, so he missed the auction, only to find that the patronage of St Aldate's had been purchased by Simeon's trustees. Had the bishop's horse not lost that shoe, the tradition at St Aldate's might be quite different today. I must move on to conclude, but it's worth mentioning that a thought-provoking article entitled "Advowsons and Private Patronage" appeared in the September 2019 issue of the Ecclesiastical Law Journal. The author was Teresa Sutton of the University of Sussex, who I think is with us this evening. In her article, she acknowledges some of the potential benefits of private patronage, but nevertheless argues that it should be given the sunset treatment. For the moment, though, the 1986 measure holds the line. My 4 decades in ecclesiastical practice happened to coincide with a period of, by church standards, significant change. I came in with the Endowments and Glebe measure, and at a time when there was pressure to abolish private patronage. As we've heard, I became involved in legal challenges over the employment status of the clergy, the exercise of statutory powers by bishops, the ordination of women, and much else. The more recent arrival of the clergy discipline measure brought with it prolific new activity, and I salute the recent efforts of the ELS Working Party in that context. Then, of course, we had clergy terms of service and common tenure in 2011, not to mentioning the burgeoning new sphere of safeguarding, with all that entails. It's been a fascinating journey, and I've been privileged and fortunate to make it. Thank you very much for listening.
Thank you very much indeed, Paul. Before that we've got time for questions, so before I even begin to thank you for that extraordinary tour de force and account of the last 4 decades, I'm going to open this up to questions. So just a reminder to use the blue hand function if you would like to ask a question, either which can be found under the participants button, or for some people it seems to be under the reactions button. Anyway, hopefully I will be able to see it, and Anne-Marie and Russell will be looking out for your hand as well. So do raise your hand if you would like to ask a question.
I was appointed as Diocese Registrar at Lichfield in 1988 when I was about 48 or 50. And my firm had done no ecclesiastical legal work before at all. So I was sort of shoved into a totally new role. I was fascinated to hear what has been said about the new legislation going through during that period. The patronage benefits measure was coming in more or less at the time I was appointed. I was very interested and fascinated to hear what Paul has said about the various bits of legislation which has gone on. What I would like to ask him is whether he thinks that the way registrars provide legal services for the diocese is a system which will remain unchanged, or does he feel that there are changes in the offing?
Well, that's a very interesting question. I suppose one change that has already taken place is that it's becoming commonplace for one registrar to look after several dioceses, or at least certainly to look after 2. I think at one time, I think I was the only registrar who was registrar of 2 different dioceses. Now that is quite common. So I think a pooling of resources is one thing that has happened. I think also that, quite honestly, the workload of registries generally has increased, and the workload of registrars too. I mean, I briefly mentioned safeguarding, and of course the clergy discipline measure produces a huge amount of work. So I think that as far as the demand for legal services goes, I think registrars and their colleagues will be needed for the foreseeable future. But of course, one can't rule out some kind of massive reorganisation. And I think one feature of the Church of England, which really in London and Southwark we've been rather sheltered from, is the decline in the numbers really of the parish clergy, whereas the diocesan staff, the administrative staff, have tended to increase, and there's been no reduction in the number of bishops, for example, or archdeacons and so forth. So I think that's one change. But to answer your specific question, I can't see that. I don't think there'll be any major change in the foreseeable future. But of course, I could be proved wrong.
Do you think the system will provide lawyers who are prepared to work for the Church of England at below the sort of commercial rate which they might be able to attract in other spheres?
Well, I think the General Synod has done something, you know, with the help of the Fees Advisory Committee and all that. I think the General Synod has moved really some way towards improving the lot of the diocesan registrars as far as remuneration is concerned. But, you know, I'm always rather heartened by the number of people who seem to be interested in ecclesiastical law. I mean, I've been succeeded in Southwark, for example, by a brilliant young partner from Winkworth Sherwood, who actually is a commercial lawyer by background, and you know, I'm sure could operate in more lucrative spheres. But I mean, he seems to be genuinely fascinated by ecclesiastical law, and I think that's, you know, that is to be welcomed.
Good. Thank you very much. Thank you.
Thank you.
Thank you very much. Okay, so we're now going to go to Alex McGregor and then James Behrens.
Thank you very much for your talk, Paul. It's been very good to hear all that. You've talked a lot about the change that's happened over the last 40 years. Would you say that overall the change has been for the better or for the worse? And would you be able in good conscience to encourage young legal practitioners to practice in this area of law and become seriously involved in it?
Do you know, when I first joined Winkworth and Pemberton, I think that the ecclesiastical practice was pretty much 50% of the whole. About 10 years ago, I think it was 8%. And I think it's less. I mean, I think I haven't got the up-to-date percentage at the tip of my fingers, but it's probably well under that figure now. But of course, the big change has been that the firm is vastly bigger. Actually, our firm's ecclesiastical practice is bigger than it was when I started, not smaller. But of course, it's a much, much smaller percentage of the whole. And I think the problem is for people who practice ecclesiastical law within a commercial firm, the difficulty they always face is making a sufficient commercial return from it. I think, as I was saying to the previous questioner, I think there's a really heartening amount of interest, even among younger people, in ecclesiastical law. But I think there are commercial constraints which would affect lawyers practicing certainly in the bigger firms and certainly in central London firms. But long may there be registrars.
Thank you very much. Thank you, Alex. So James Behrens.
Paul, thank you for everything you've said. How do you as a registrar handle the situation where there is a conflict in a faculty case? Because you tell the parish that they need to get a faculty, and then you find that the faculty petition is opposed. How do you get somebody else to act for one party or the other?
Yes, well, that's a very good question, James. And of course, it's a question that arose specifically in the case of Spitalfields, which you will know about. Yeah. Well, I can only say really what the practice has been in my own firm, which was this, that we did allow people to act for a parish, even in proceedings before the consistory court. And even though one of the partners in the firm was the registrar of that particular diocese, we did allow that. We didn't allow the registrar to act, of course. So there was a Chinese wall within the firm, and that's how we did it. And you know, and I've been asked this question before, and I reflect on a case that we had in the Diocese of London very early on in my career, which was a church. I just don't remember the name of it. It was a church out in West London, in the suburbs, in Emmanuel Northwood. It was Emmanuel Northwood in West London, and there was a big contested consistory court case which lasted for 5 days, 5 full days hearing, and the judge was Sheila Cameron, but both counsel for the opponents, counsel for the parish, both counsel also came from her chambers. And I mean, I honestly think that case was conducted to the highest professional standards, and I don't think that there was any kind of real conflict that in any way affected the outcome. And I'm afraid that's the view we have taken hitherto in Winkworth-Sherwood. But I do appreciate the point, and it is a point that concerns some people, and it is a point that was discussed at some length in the Spitalfields case.
Thank you.
Thank you very much, James. Okay, so we're going to go to Edward Dobson and then Ian Blaney.
Paul, thank you for that really fascinating talk. It's been really interesting to hear. And as somebody who's come into ecclesiastical law quite recently, it's been fascinating to hear your time in it. I wondered, as somebody who was obviously in practice at the time of the EJM and when clergy discipline was dealt with under that measure, what your reflections were at the time the new CDM came in, and in particular the differences between the two, if you think it's been an improvement on that.
Well, I think there's a massive difference. I mean, discipline cases under the EJM were very rare. And when they did happen, they did tend to attract publicity, and I think not really in a very helpful way to the church. I mean, I remember particularly there was a case involving the Dean of Lincoln, a former Dean of Lincoln, I hasten to say, which involved proceedings in the consistory court. And, you know, I think that case actually was one of the reasons why, when the clergy discipline measure came in, proceedings were to be, generally speaking, in camera, unless there's some good reason or the respondent wants the thing to be in public, of course. Now, as to the differences, I mean, one, there were hardly any cases under the EJM. I mentioned the feud between Bishop Mervyn Stockwood and his Chancellor. That actually was caused by proceedings under the EJM that resulted in deposition of one particular priest I happen to know in the Diocese of Southwark. And the bishop was dreadfully upset because he contended that he had been advised that there had to be a service of deposition in the cathedral. And he's discovered subsequently that wasn't really the case. And he felt awful about it and even thought of resigning, apparently, at one point. So he and his Chancellor were not on speaking terms thereafter. But turning to the clergy discipline measure, that is a totally different animal. And my own personal view is that the problems with it have not really been with the measure itself at all, but the way it's been used. So many people seem to use it as a grievance procedure. So many people seem to use it to, if they just don't like the vicar and you know, want to make a bit of fuss. The trouble is that it is so difficult for bishops just to dismiss complaints without really hearing both sides of the story. And the current Bishop of London is particularly good, actually, at always giving parties to these cases an opportunity to actually talk to her personally, and she does that extremely well. But it's not a cheap way of proceeding, really. I think, well, I remember one thing, when the CDM came in, there was a lot of talk about the standard of proof. And everybody was saying, oh, isn't this going to be much better because it's going to be on a balance of probabilities, much better, it's unworkable, the 63 measure, because, you've got to prove it beyond reasonable doubt, the criminal standard. And now what's happening, of course, is people are now complaining about the standard of proof in the CDM. So I forget where it was, I read somewhere that, whatever regime you have, people complain about it. And it's then replaced by something different, and they complain about that. My own personal view is there should be a way of dealing with minor issues which doesn't involve the full panoply of the CDM. That's the first thing. And secondly, when the CDM is used, I think it should be used with a little more discretion. For example, I think bishops are in a very difficult position, because usually when a complaint comes in and the registrar does a Section 11 report, the bishop and the registrar have normally only heard one side of the story. And sometimes the story can be quite convincing. And very often, if everything that is said is true, well, yes, it could be misconduct. Whether it's serious misconduct is another matter. But I mean, it does say in the Code of Practice that it's not a grievance procedure, that it's only intended to be used for cases of, I think it says, sufficient seriousness that might warrant a tribunal hearing. I think it says that. And for that purpose, I think the measure is, in my view, is actually pretty fit for purpose. It may need some tweaking here and there, but I know the wish of many is to abolish it and put in something new. But I mean, you I think have a very special role in relation to the measure, do you not? Yes, yeah. Well, you have my sympathy, but that's what I think of the CDM anyway. And yes, huge difference as from the 1963 measure.
Thank you very much. Thank you, Edward, and thank you, Paul. Okay, so next, if we move to Ian Blaney and then June. Sorry, June, I don't have your surname on the screen, but Ian Blaney first.
Thank you for your talk, which I enjoyed, and thank you for your professional and polite conduct to me during the short time I've been involved with ecclesiastical law in difficult matters.
It's always been very nice to deal with you.
Thank you, Paul. The Diocesan Registrar is a legal officer rather than an employee of the bishop or the Diocesan Board of Finance, and the Diocesan Registrar provides his or her work otherwise than merely by way of professional services through a firm of solicitors. From your years of experience, how does the character of the registrar being an office holder affect that work? Do you think that is a beneficial thing, or is that something that ought to be swept away?
I don't think it should be swept away. In a way, it reflects James Behrens's question, doesn't it? I mean, James was asking about conflicts of interest when, say, a firm is involved in a faculty case and the registrar of the diocese is a partner in that same firm. I don't think it's, personally, I don't think it is a real problem, but I do think that potential conflicts need to be recognized, need to be managed, and that those involved need to be aware of them. So I think, for example, in consistory court proceedings, if one party says, look, we're not happy with this, we've got a solicitor from Winkworth Sherwood who's representing the PCC, and the diocesan registrar is a partner in the same firm. We don't. Well, I think that is the kind of issue that can be raised, and I think in those circumstances, alternative arrangements could be made. But we need to remember that ecclesiastical law is quite a small pool of expertise. That's why the situation existed in that case I quoted at Emmanuel Northwood. of the three participants, the judge and the two counsel, all being from the same chambers. I take your point. I think that those partners in firms who are registrars need always to remember that the registry is a public office, for example. You in your firm will be particularly aware of this with the faculty office. And for example, the resources of the registry must be available to the public for the purpose of common marriage licenses and so forth. That's an important point. And I think the point about potential conflicts needs to be raised. But overall, I think it is of great advantage to the diocese to have the supporting expertise of other members of a registrar's firm. And I've been very fortunate to have excellent collegiality from our litigation department, from our employment law specialists, and so on, which has been a huge help. I mean, even all those years ago with the Coca case, it was hugely helpful to have expert litigators on hand. Does that answer your question?
Yes, it does, Paul. Thank you very much. I'm very much a champion for the registrar being an office holder rather than a mere employee. So I'm glad you're also willing to champion that aspect of the role.
Thank you very much, Ian and Paul. Okay, so we're going to move on then to June and then Olga Pierce.
You need to unmute yourself.
I'm on mute. Good afternoon, Mr. Morris. Won't surprise you.
Good afternoon. Very nice to see you.
It won't surprise you. I don't entirely agree with your last comments. I was very concerned about the representation point. There is a total legal difference between members of the bar over many centuries appearing from the same set of chambers, appearing against and indeed in front of each other, mainly because we are all individuals and practice as individuals and not as partners. So the economic advantages to each of us do not accrue to the other members who might appear either with us or for us. So that's a very great difference. No solicitor, as I understand it, in High Court, County Court, Family Court matters would appear in front of an acting registrar or recorder of his firm. It would just not be acceptable, not legal. I was concerned and that there can be this perception, and I think these days with growing involvement of the outside world in perceived fairness, that many people cannot understand how a parish can be advised. Many properties, what they pay for on the quota, can be advised on a legal position and then discover themselves in a court where the people advising them appear to have a public role in whatever way, be it directions or whatever. I think it is very risky, and I did make this clear in Spitalfields, as Mr. Morris is well aware. I think it's legally a very dubious and situation. It's not, I think, an excuse to say it's a very small world. That, I think, is a very worrying scenario. Many people, and we've heard people asking questions tonight, who've come into it absolutely afresh and can pick it up. It's not rocket science. It's not rocket science. So I think just to say it's a small group, that is in itself a very worrying scenario. I haven't really got a question, I've just got a comment, but I do think that your analysis of a couple of members of Sheila Cameron's chambers appearing in front of her to be analogous is not legally analogous. Anyway, I'll stop now. Thank you. Nice to see you.
Thank you very much. Very nice to see you, and I completely understand what you're saying.
Thank you.
Thank you very much indeed. Olga Pierce, and then Colin Buchanan.
Yes, thank you. Paul, you and I are almost the same vintage.
Very nice to see you again. Yes.
Thank you very much. Yes. Now, I was in ecclesiastical law in the narrow sense, basically in the 20th century. Then I was in academia, looking at slightly wider issues in the 21st. And in the 20th century, ecclesiastical law was indeed a small pool. There were very few people who did it. And until the society sort of began in the late 1980s, very few people even knew about it. I mean, it had, of course, been wonderful before they lost the probate and matrimonial jurisdictions, but that was a century ago. And then looking at it from the point of view of the academic specialist in the interaction of law and religion, I see a huge watershed in the year 2000 when the Human Rights Act came into force, because suddenly there was money in arguing your religious convictions. The legal profession took it up, and academia took it up so that they could feed the legal profession with ideas. My question is, did that watershed, from the point of view of your experience in practice as a registrar, make any significant difference at all? Or did ecclesiastical law in the narrow sense continue exactly as it had done before?
Gosh, what a question. Well, I mean, I can't say that it had no effect. I think, for example, one of the justifications for the clergy discipline measure was, in fact, the Human Rights Act, because it was thought that there needed to be some kind of system that was Human Rights Act compliant. So I think it has affected the way church law has developed, but in all honesty, I can't say that it's had any made any significant difference to my work as a registrar, apart from, of course, from the need to be aware of human rights, the Human Rights Act, and indeed because we had seminars in the firm on it and all that when it came in. But I think the short answer to your question is not really.
Okay, thank you very much.
Thank you. And Colin Buchanan.
Am I mute?
We can hear you, I think.
Are you hearing me?
Yeah.
Oh, fine. Well, first of all, I'd want to greet Paul and thank him very much for services in my Southwark days. And I wondered whether he was referring quite a bit, without mentioning him, to David Fall. And I just thought that a man with the memories going back, it would be just last chance to hear about David Fall, whom I shadowed for some years as a friend when he was getting Mervyn Stockwood out of trouble for about 20 years. And if Paul has got memories of that, or just like to say a word about David Fall, I'd be very grateful. If there's another second after that, I've got a funny myself, I can tell, against Paul, but he'd have to give permission for that, for you to go ahead with that one.
Well, I'll certainly say a word about David Fall. David Fall was my immediate predecessor in Southwark. He was a former senior partner of Winkworth Sherwood, a very distinguished lawyer. He was on the solicitors' disciplinary panel for many years. He had a passionate belief in the need for social housing and was one of the founders of what was then Paddington Churches Housing Association. But yes, as you've said, he was a tremendous friend of Mervyn Stockwood. And I briefly touched in one answer on the business of depositions under the 1963 measure, and Bishop Mervyn being very upset about that. And the story goes, in fact, it was mentioned in an obituary in the Independent, I think, of David Fall, that David was instrumental in persuading Bishop Mervyn not to resign over that issue. So he was very, very much a force in the Church of England and very much a force in Southwark. I briefly mentioned South Bank religion. I mean, this goes back to the days of people like John Robinson, who was Bishop of Woolwich, honest to God. You know, I'm old enough to remember honest to God coming out, it actually being controversial. And when I remember when John Robinson went to preach at Westminster Abbey one Sunday evening, the queue was all the way around Parliament Square. There were so many people wanted to hear him. This is South Bank religion. And of course, David Shepherd, the great cricketer, he was another Bishop of Woolwich. And of course, Colin yourself, you know, very much a Southwark bishop too, all part of the great story of the diocese. But yes, David Fall was very much part of the place, a very important figure in the Church of England, a very important figure in Winkworth, Sherwood. He's a great person.
Can I tell my Woolwich story then?
Do.
I did an ordination in the old Royal Naval College Chapel about 20 years ago, and the registrar issued letters of orders for those ordained, which had the old Royal Naval with the naval spelled N-A-V-E-L. So the Royal Naval Chapel was a very odd place indeed for the ordinations to take place. Unfortunately, I think those letters of orders got destroyed, whereas really they ought to have been framed. Do you know that, Dame Paul?
Well, I don't know. I don't know who was responsible for that, Colin. I really don't.
Thank you very much.
Thank you very much. Thank you very much indeed. We're just coming up to towards 5 to 7. Just before we finish, Paul, if I could ask you just one question, which is about a marriage law, which forgive me, I don't think it was such a full lecture you gave, but I would be interested to know particularly your thoughts around marriage preliminaries and the role of surrogates, not so much looking backwards, but going forward with the changes through the Immigration Act and so on, and whether you think there is a future for marriage preliminaries, common licenses, and so on, which are obviously a staple of registries, as well as surrogates like me.
Well, of course, we're issuing so, I say we, I'm not there now, so I haven't been for some months, but the number of common licenses being issued by the registry has gone down tremendously. I don't know, I haven't really given this an awful lot of thought. I don't particularly want to go on the record about my view on marriage preliminaries, but I will just say something about common licenses, because we had a very, very worrying period when there was a huge upturn in the issue, well, there was a huge upturn in applications for common licenses in the metropolitan dioceses, particularly London, Southwark, Rochester. And it was quite clear that what was going on was that there was some kind of scam, and that sham marriages were being entered into. It's a very difficult subject, actually, because historically there have been sham marriages that have been entered into for noble reasons, wartime, for example. But there clearly was a great scandal, which is one of the reasons why the recent change in the law as to when one party is coming from abroad, say, outside the European Economic Area. That's why the law has changed, and civil preliminaries have to be followed, effectively leading to a superintendent registrar's certificate rather than a bishop's license. So really, it's not a huge issue, quite honestly, Stephen. The number of licenses issued has gone down. Southwark is, no, London, of course you're London, aren't you? Both London and Southwark are very good in the way they operate with surrogates to do the affidavit and so on, and enable the license to be issued by the registry. But I don't think I have a particularly strong view really on on marriage preliminaries. I mean, I'm very, very keen, of course, that marriages in church should be encouraged, but that is not necessarily the same thing as insisting on ecclesiastical preliminaries.
Thank you very much, Paul, for answering that. Thank you. Can I just, it's just coming up to 7 o'clock. Paul, can I just say a huge thanks on behalf of the ELS and on behalf of everyone here for an absolute, well, I've said earlier, a tour de force this evening. We've heard some fascinating developments in ecclesiastical law and some great and very entertaining stories spanning 4 decades. So thank you very much. And I think the number of questions and the fact that we've run on right to 7 o'clock just shows how fascinating we've all found it. So thank you. Just before we bring this evening's lecture to a close, just a reminder to everyone that details of the Society's future events can be found on the ELS website. Can I particularly mention 2 things? The first is the Virtual Day Conference, which is held on Saturday, the 20th of March, 2021, on the topic of the solemnization of matrimony, past, present, and future. And that day conference will include the Society's virtual annual general meeting as well. So please do come along and sign up for that. It was also really good, Paul, that you mentioned the ELS Working Party on the Clergy Discipline Measure, chaired by Peter Collier, QC, which releases final report today. And I would encourage those present to take a look at the ELS website, which has that report and which we hope is an important contribution to that debate on the reform of that measure. Thank you all very much indeed for joining and for the thoughtful questions, and a particular thank you to Anne-Marie and to Russell for flawlessly running the technology. But most of all, on behalf of us all, Paul, thank you so much for a fascinating and entertaining lecture.
Great pleasure.
Until next time. Thank you. Thanks.